these guys to sue you, the military officials that were responsible for it. So here we are. After 2006, we just argued in December the case called Boumediene versus Bush and Al-Oda versus Bush. And the Boumediene case and the Al-Oda case is the argument that the constitutional right to habeas, now, not just and Congress can't do anything about this. This is the Constitution. It applies to the man in Guantanamo. The Supreme Court heard the case in December. I was telling Joe that I thought we heard rumblings that they were going to come out with some decisions today, and I was concerned that it was going to happen today. But it will happen between now and June, which is the last day. So keep your eyes peeled for the habeas corpus decision from the Supreme Court. When it comes out, you should take a look at it and you should read it. We don't know what it's going to say, but I'll tell you what I think it's going to say very quickly. I think it's going to say that the constitutional right to habeas corpus does apply to the men in Guantanamo, which would mean that we're back to square one. So we go back to federal court and we pick up where we left off. Nobody gets out of jail. But it will also say that there's this little thing that, you know, Congress is not suspending habeas corpus if the military comes up with a reasonable alternative to habeas corpus that has all the sort of the checks and balances. And the argument that the administration is making is that this DTA process and the CSRT process, where you don't get a lawyer and you don't get to hear the evidence and you don't get all that kind of stuff, that is an adequate substitute for habeas. So the court can say, hey, habeas corpus applies, and yes, Congress suspended habeas corpus, but they came up with this nice little alternative, so you guys stay in jail and you go through this DTA process. Or they could say, habeas applies, Congress did suspend habeas, and this DTA process does not get you out of the box. So these guys get to go in federal court. And either way, we always have to keep mindful, especially in an election year, of what Congress is going to do. Because Congress could very well say, if there is a victory and these guys want to go into federal court, Congress can say, we're going to come up with something else. We're going to monkey with it a little bit more to make these guys jump through more hoops. Bottom line is that we need to move beyond this idea of indefinite detention and torture here in the United States. I know that there's a lot of you who are a group of very astute people, and I know that I dropped a lot of information in 43 minutes. But I would encourage you to look at the CCR website, and our website is www.ccrjustice.org, where you can find out more about these cases. You can sign up for action alerts to find out about the decision and what people are thinking. But it is an extraordinary time in American history, and each of the things that I talked about, the torture, the indefinite detention, Guantanamo, the warrantless wiretapping, all of that stuff can be absolutely wiped out by the next president, literally with a stroke of the pen. There is no reason why we have to be a government that tortures in the name of national security. There is simply no reason, and there's also no legal justification for it. And so you should take that into account as you're looking at this next presidential election, and think about how what your candidate is saying about these issues, and think about what commitment they're going to make to restore, I think, a level of dignity to the U.S. in the way that it prosecutes the least of its citizens and people that are under its rule. I thank you very much.
We can take, Mr. Warren will take a couple of questions, and if you want to go out and have a refreshment, you can do that as well, because we are going to be sticking to the schedule. The next panel will begin at 2:30, so you can go walk in and out and get some food, but Mr. Warren will answer some questions.
Yeah,
in the case on the airline, I remember reading about it. Unfortunately, I'm not that well versed, but would your organization also assist the plaintiffs in that case in bringing civil cases against the people that reported the suspicious activity on the aircraft, the actual passengers?
No, that was the case that I did was when I was at the ACLU. We brought a civil lawsuit against the airline for throwing people off the plane because some people on the plane were nervous about them just because they were Arab. They looked like they were Arab or Muslim. It turns out that none of the three were Arab or Muslim.
I think wasn't there some conversation, a little bit more than that, or it was just merely
two of them were
activity as well?
There was no activity. Two of them were actually colleagues from the University of South Florida, so they got on the plane together. Any other questions? Yes.
I'd be interested in hearing your idea of what would be an appropriate due process for determining whether a terrorist, an alleged terrorist, should be detained or not, needing to possibly detect the intelligence sources and the like, and protect public harm is not a simple criminal you're letting loose. It's somebody who's intent on killing as many people as possible.
Right.
So we need, it seems to me, a process that will sort out people like this poor guy in Afghanistan from people who would gladly slit their throats as soon as they got them out of jail.
Right, that's great. The question is, what would a proper due process situation look like in an age of terrorism where we have people that clearly are floating around that are terrorists, that would be able to sort the people that are innocent from the people that are guilty? And I think, and I don't say this facetiously, but that process is called criminal trials, and we actually have them in the United States. And if you think about the federal criminal trials that we've done relating to terrorism, there was a Jose Padilla trial, there was the 1993 World Trade Center bombings, there was the Oklahoma City bombings, there was the shoe bomber, there were a whole range of people. None of these guys, I mean, there were problems with some of the way that they were detained, certainly, but none of these guys, the process that they went through, it was all federal courts. In fact, let me just say, there's this interesting thing where the military commissions are back. I didn't have time to talk about it. But there was a man who was the government said was part of a 4 or 5 person conspiracy to blow up an embassy. I believe it was in Tanzania. 3 of his colleagues were indicted, arrested, and convicted in federal court 3 years ago in New York. He was indicted, but they didn't have him yet. Well, they found him somewhere. And instead of bringing him to federal court to face trial like the other guys, they decided that they wanted to mine him for intelligence value, so they sent him to a CIA black site for 2 years and tortured him. And so they bring him to the Guantanamo, and you would think that because all of the evidence is in federal court and because every single one of his co-conspirators is spending their lives in prison after having gone through this process, that the government would send him to federal court. But no, they send him to Guantanamo, and then they're going to put him through a military commissions proceeding where death penalty is on the table, just like it was in federal court. But there's no reason, there's nothing about his situation that is different from those men. If they were able to be tried successfully in federal court, he is too. The only reason why he's not is because he was in a CIA black site for 2 years and he was tortured. And we know that if they brought him to federal court now, under our federal rules of evidence, you can't admit evidence that's gained by torture. It's illegal. You can't do it in federal court. So the decision to torture people has actually been the primary reason why these guys are not being tried in federal court. That's the answer to that. Anybody have any other? Yeah.
Yeah. You said that the U.S. government was responsible for sending Mayor Arar. I don't know if I
Yes.
understand correctly. Which organization is responsible? Is it the CIA or Homeland Security? And also, who are you looking to punish in the case? Is there a specific person or this organization?
It's an excellent question. I really wish I had more time to talk about this case, but I will try to answer your question specifically. We know that Immigration and Naturalization, Homeland Security, and the FBI were involved in the American side. We know that the Canadian Mounties, the Royal Canadian Mounted Police, were involved on the Canadian side. We have a FOIA, Freedom of Information Act lawsuit that's pending to get more information. Normally you get information on these cases by filing the cases through a process called discovery, where you say, here's what's going on. They give you the information, you give them your information. But they've taken the position, the government's taken the position, that anything relating to Maher Arar's case is secret evidence. And so they're not giving us anything. So we have to do Freedom of Information Act requests to get the documents. So we don't know all of the agencies that were involved. And I'll say 2 more things on Maher. One is that the lawsuit is against John Ashcroft, who was then the Attorney General who authorized the situation, and I believe it's against George Tenet. I'm not 100% sure for the CIA role. And it is seeking an injunction, which is to stop this program moving forward of rendition, and it is also seeking monetary damages on behalf of Maher Arar. And here's the other piece I want to say. Canada, right, the U.S., right? Maher Arar, by the way, even though everybody acknowledges is not a terrorist,